Hey folks, I wanted to tell you a little story about the very first case I tried and the biggest 2 lessons I learned from it, which may surprise you. It was in my very first year of private practice. It involved me representing an elderly lady who was in a low-impact car wreck where she suffered a sore neck and back, and she really was sweet. During the trial, she offered to buy me a fish sandwich from McDonald's for lunch. I was scared to death. I couldn't eat anything, but I sure did appreciate the offer. Anyhow, here's the top 2 lessons I learned from that trial. Number 1, the wrongdoer, that's the legal name for the defendant, is human too. Treat them that way unless they give you a real good reason not to. Now, don't misunderstand me. That doesn't mean I treat your case like it's just spilled milk or pretend everything's okay. A trial is still about holding the defendant accountable for the costs of their carelessness you shouldn't have to bear and certainly didn't deserve. We're going to point out their wrongdoing and do it firmly and rightly. But it doesn't mean I paint them to be evil when they're not. And here's why. Juries are people too. People who've made mistakes and don't want to be put on trial for it. So if I treat the defendant like they're evil for no good reason, it can backfire where they despise me, feel sorry for the defendant, then take it out on you by giving you a bad verdict, which defeats the whole purpose of the trial and my professional existence. So here's what I did in that trial. During my opening statement, that's when you're talking to the jury for the first time as a lawyer, telling them about your case. At some point, I pointed over at the defense table and said real snide-like, and sitting over there with her lawyer is the defendant. I mean, like the defendant was a criminal and like my client didn't have a lawyer too. And as it turns out, the defendant was a really nice lady. It backfired, no doubt in my mind. Number 2, be honest and ask for help. In that trial, I faced off against a highly experienced and vastly talented defense lawyer. And at one point, he asked me if he could read some deposition transcripts into the record as evidence in front of the jury. I honestly had no idea whether court rules allowed that. And here's the quandary I found myself in. I could either fold and just tell myself his experience surely justified his request, or I could admit to the judge I didn't know the rules of court, which is a terrifying thing for a lawyer to do. Well, he announces his intention to read those transcripts and evidence, and I just piped up and said, Judge, I don't know if he can do that. If he can do that, I consent. If he can't, I don't. Can he do that? Well, the judge was gracious and merciful. He just shook his head and said, no, he can't do that, so it didn't come in evidence. By the way, all of this took place outside the presence of the jury. When lawyers are conducting a legal argument for the judge to make a ruling of law, the jury goes back to the jury deliberation room, so they never saw a second of this. Well, I bet you're wondering how the trial turned out, or maybe you already figured it out. I lost. My client was shocked, which I took as a real good sign. Best of all, the highly talented, highly seasoned trial lawyer I went against was equally shocked to find out it was only my first trial. Well, I've tried a lot of cases since then, and I learned something every time. So put my experience to work for you. If you've got any questions or worries about a South Carolina accident case, call me. I'm just going to answer your questions. I'm not going to strong arm you to hire me, and I'm going to let you make the right decision for you. I thank you for thinking about this with me, and I hope I see you soon.